Disclaimer: the information presented in this broadcast is strictly for educational and entertainment purposes only and does not constitute formal legal counsel, privacy advice, or professional investigative guidance. The laws surrounding electronic surveillance, vehicle tracking, and individual privacy within the United States are exceptionally complex, continuously evolving, and vary drastically from state to state, as well as across different federal jurisdictions. What is considered a perfectly legal asset protection strategy in one state may be classified as a felony stalking offense in another. We are analyzing historical trends, legal case studies, and publicly available statutory frameworks to understand the broad landscape of location tracking. Viewers must conduct their own independent due diligence and consult with a qualified, licensed attorney in their specific jurisdiction before making any decisions regarding the installation, deployment, use, or removal of any electronic tracking devices. Misuse of GPS and tracking technology carries severe potential outcomes, including criminal prosecution, significant fines, and devastating civil liability lawsuits. Proceed with this educational content at your own discretion. Imagine finishing a long, exhausting day at the office, walking out to your vehicle in a dimly lit parking garage, and driving home. You stop at the grocery store to pick up dinner, you swing by your local gym for a quick workout, and you finally pull into your driveway. Now imagine that every single turn you made, every stop you took, the exact route you chose, and every minute you spent parked outside a specific address was being meticulously logged, recorded, and transmitted to a stranger's computer screen or smartphone in absolute real time. You would never know it was there. A device no larger than a standard deck of playing cards, silently clinging to the metallic undercarriage of your vehicle with industrial-strength neodymium magnets, acting as a permanent digital shadow. This scenario is not a fabricated scene from a Hollywood espionage thriller, nor is it a paranoid dystopian fantasy. This is a daily documented reality for thousands of Americans. According to historical trends and extensive legal case studies across the nation, the deployment of covert GPS tracking devices has exploded in recent years. This surge is directly correlated with the rapid miniaturization of technology, the extension of battery life from days to months, and the plummeting consumer costs of cellular data transmission. But here is the highly controversial and deeply unsettling reality that the vast majority of people completely misunderstand, depending entirely on exactly who placed that tracker on your car, their specific motivation for doing so, the legal ownership status of the vehicle, and the exact state jurisdiction you happen to be driving through at this very moment. That extreme invasion of your perceived privacy might be completely and entirely legal under the letter of the law. To fully grasp the magnitude of this situation, we must examine the evolution of the technology and how it routinely outpaces the legislative process. Decades ago, tracking an individual required a dedicated team of private investigators physically tailing a vehicle, maintaining visual contact, and risking exposure at every intersection. It was an expensive, labor-intensive process reserved for high-stakes litigation or wealthy clients. Today, anyone with $50 and a basic internet connection can purchase military-grade telemetry equipment that was previously restricted to advanced intelligence agencies. There are two primary categories of these devices that the courts have had to evaluate. First are passive data loggers, which simply record a vehicle's coordinates to an internal memory card, requiring the user to physically retrieve the device later to download the travel history. Second, and far more common today, are active real-time cellular trackers, which constantly broadcast their precise coordinates through cellular networks, allowing a monitor to watch a vehicle move live on a digital map. The legal system has struggled immensely to categorize these devices. Is placing a tracker on a bumper merely a modern extension of observing a car driving on a public road, which requires no legal justification? Or is it a fundamental breach of physical property and personal privacy? Let us examine a practical case study to illustrate how easily ordinary citizens wander into a legal minefield. Consider a small business owner who suspects a field technician is utilizing a heavily branded company van for unauthorized, off-the-books side jobs during operational hours. The business owner, seeking to protect their assets and verify employee time cards, purchases an active tracker, attaches it to the van's chassis, and watches the location data roll in from their office dashboard. Alternatively, consider a highly suspicious spouse entrenched in the middle of a bitter, contentious divorce proceeding, desperate for leverage regarding child custody or hidden assets. This individual slips a small battery-powered location beacon deep into the glove compartment of the primary family SUV. Both the business owner and the suspicious spouse operate under the assumption that they are simply gathering factual evidence, exercising an inherent right to monitor assets they financially maintain or legally co-own. However, evaluating the potential outcomes reveals a stark contrast. Based on specific state statutes, the business owner might be acting entirely within their legal rights to monitor company property, while the spouse might be committing a severe criminal offense categorized as cyberstalking or unlawful surveillance, potentially leading to immediate law enforcement intervention, restraining orders, and severe civil penalties. The dividing line between legally sanctioned asset management and criminal stalking is incredibly complex, heavily nuanced, and fundamentally misunderstood by the general public. The stakes regarding this technology have never been higher, as we are currently standing at the volatile intersection of constitutional rights and modern digital capability. The Fourth Amendment of the United States Constitution heavily protects citizens against unreasonable searches and seizures, but the judicial system has had to meticulously interpret how a document drafted in the 18th century applies to a constellation of satellites orbiting the Earth, bouncing microwave signals off a piece of plastic magnetically attached to a modern exhaust pipe. The United States Supreme Court has actively grappled with this exact paradigm, fundamentally altering the landscape of digital privacy. In the landmark case study of United States v. Jones, federal law enforcement agents attached a GPS tracking device to the undercarriage of a suspect's Jeep Grand Cherokee without a valid, active warrant, subsequently tracking the vehicle's movements continuously for 28 days. The legal fallout from that single investigative action sent massive shockwaves through the American justice system. The Supreme Court ultimately ruled that the physical installation of the device on the vehicle constituted a trespass on private property for the purpose of obtaining information, thus qualifying as a search under the Fourth Amendment. Furthermore, concurring opinions introduced the critical mosaic theory, suggesting that while observing a single trip on a public road might not violate privacy, the continuous, long-term monitoring of every single movement creates a comprehensive mosaic of a person's life, revealing their doctors, political affiliations, religious practices, and personal associations, which heavily violates a reasonable expectation of privacy. Yet, that massive Supreme Court ruling primarily restricted the actions of the government and formal law enforcement agencies. What happens when it is not a federal agent tracking your movements, but rather your current employer, a jealous ex-partner, a suspicious family member, or a licensed private investigator hired by a rival corporation? The constitutional rules of the game change entirely, shifting from federal constitutional protections to a chaotic patchwork of individual state laws and civil torts. This massive discrepancy creates an urgent, critical knowledge gap for the average citizen. You might be navigating your daily life right now, completely oblivious to the massive digital footprint you are generating, and wholly unaware of the specific legal parameters governing exactly who is legally permitted to collect, store, and utilize that deeply personal data. That is exactly the complex legal web we are going to untangle and clarify for you today. If you have ever wondered whether it is strictly legal to track a vehicle you hold the financial title to but rarely drive, if you are deeply concerned that an unknown party might be monitoring your daily movements without your explicit knowledge or consent, or if you simply want to thoroughly understand the modern boundaries of American privacy in the digital age, you are in the exact right place. This educational masterclass is systematically designed to provide you with a comprehensive, deep dive into the specific legal frameworks governing GPS vehicle tracking across the United States. We will systematically break down the critical legal distinction between state-sanctioned law enforcement tracking and private, civilian tracking operations. We will explore the absolute core concept of consent, examining the vast, critical differences between tracking a vehicle you exclusively own versus tracking a vehicle owned by a third party. You will learn extensively about the intricate state-by-state variations, observing how simply crossing a state border on an interstate highway can instantly transform a legally permissible monitoring operation into a severe criminal charge. We will heavily analyze the legal impact of shared vehicle ownership, community marital property laws, and complex employer-employee operational relationships regarding the legal expectation of privacy. By the conclusion of this extensive presentation, you will possess a thorough, actionable understanding of the historical trends shaping these surveillance laws, the severe potential outcomes of violating these statutes, and the precise foundational knowledge required to safely navigate the incredibly complex intersection of consumer tracking technology and legal liability. We are removing the harmful guesswork, discarding the widespread internet myths, and delivering a factual step-by-step examination of exactly what the law currently dictates about the digital trackers silently navigating American roads. To thoroughly understand civilian GPS tracking laws, we must first establish the absolute bedrock of the legal framework, which centers entirely on the concept of legal vehicle ownership and explicit consent. When formal law enforcement and judicial warrants are not involved, the entire legal structure determining whether a tracking operation is a smart security measure or a criminal offense hinges on who legally owns the vehicle and who has granted permission to be electronically monitored. This determination is not based on who pays for the gasoline, who washes the car on the weekends, or who currently possesses the primary set of keys. The legal system looks directly and exclusively at the specific name printed on the government-issued vehicle title and the official state registration documents. If you are the sole, exclusive legal owner of a vehicle, you generally possess a broad legal right to affix a GPS tracking device to your own personal property to monitor its location, protect it from theft, or recover the asset if it is ever stolen. However, this foundational rule becomes incredibly intricate and highly dangerous the exact moment another individual gets behind the steering wheel, because you are no longer simply tracking a piece of metal and plastic traversing a highway, you are tracking a living human being and building a database of their daily movements. Let us examine a highly common scenario rooted in extensive historical trends regarding modern auto financing. Imagine you walk into a subprime auto dealership in the current year 2026 to purchase a reliable sedan to commute to your new job. Because your credit history might be less than perfect, the dealership requires you to sign a high-risk loan agreement to secure the vehicle. Buried deep within the dozens of pages of that dense financing contract is a specific legal clause granting the lending institution explicit, irrevocable consent to install an active GPS tracking device and a remote starter interrupt system on the vehicle. In this specific case study, the dealership maintains a legal financial security interest in the vehicle until your final payment is successfully processed. They are leveraging the tracking technology to directly mitigate their financial risk, ensuring they can easily locate, secure, and repossess the physical asset if you default on the monthly loan payments. Because you voluntarily signed that contract, you provided explicit written consent to be tracked. The potential outcomes of tampering with, disabling, or physically removing that specific device are incredibly severe, often resulting in an immediate breach of contract, the rapid repossession of the vehicle without further warning, and massive civil liability for intentionally damaging the electronic telematics equipment legally belonging to the lender. This comprehensively demonstrates how formal contractual consent legally overrides your personal expectation of privacy. While you are actively driving a vehicle you do not entirely own outright. Now consider a completely different case study involving familial asset management and the protection of minor dependents. Imagine a father named Michael who purchases a compact car for his 17-year-old son to drive to high school and his part-time employment. Michael pays the monthly auto insurance premiums out of his own pocket, covers all routine maintenance costs, and holds the exclusive legal title to the vehicle solely in his own name. Out of genuine concern for his son navigating dangerous highway traffic, Michael physically hardwires a covert GPS tracker deep behind the dashboard to monitor driving speeds, hard braking events, and geographical boundaries. Under the vast majority of current state laws, this action is entirely legally permissible. Michael is the absolute owner of the physical property, and as the legal guardian of a minor child, he possesses broad, sweeping legal authority to monitor his dependents for their own safety. But the legal framework shifts dramatically and becomes highly perilous the moment the clock strikes midnight on the son turning 18. Once the driver legally becomes an adult citizen, even if Michael still legally owns the vehicle and pays every single associated bill, covertly tracking an adult without their explicit, ongoing consent begins to severely test the strict boundaries of privacy laws in numerous jurisdictions. Several state courts argue that an adult driving a borrowed vehicle possesses a highly reasonable expectation of privacy, and covertly tracking them, even with the legal owner being the individual conducting the tracking, could potentially trigger severe invasion of privacy, civil torts, and significant financial damages. This directly brings us to the absolute most dangerous, highly litigated, and legally disastrous area of GPS tracking laws, which directly involves married couples and highly contentious divorce proceedings. This is the exact arena where historical trends show otherwise law-abiding citizens making life-altering legal mistakes. Imagine a married couple, David and Emily, living together in a community property state like California or Texas in 2026. Their marriage is rapidly deteriorating, and David strongly suspects Emily is deliberately hiding financial assets or engaging in illicit behavior outside the family home. The primary family sport utility vehicle is titled solely in Emily's name, having been purchased just prior to the legal marriage, but commingled marital funds are routinely used to pay the insurance premiums and vehicle maintenance. David purchases a magnetic battery-powered tracker online and discreetly attaches it to the rear bumper of the vehicle while Emily is sleeping. David mistakenly believes that because they are legally married and share financial responsibilities, he possesses an inherent legal right to monitor the family vehicle. This is a catastrophic legal miscalculation. In many jurisdictions across the country, placing a tracking device on a vehicle you do not exclusively and legally own, without the explicit and documented consent of the primary driver, is a severe, prosecutable criminal offense. Even in community property states where financial assets are theoretically shared, the judicial courts have repeatedly and aggressively ruled that one spouse simply cannot covertly track another spouse. The potential outcomes for David in this specific case study are staggering and potentially life-ruining. Emily discovers the electronic device during a routine mechanical oil change and immediately contacts local law enforcement. David could face immediate felony stalking charges, unlawful electronic surveillance charges, and the immediate issuance of a strict domestic violence restraining order forcing him out of his own home. Furthermore, in family court, the presiding judge will absolutely view the covert tracking as an egregious act of intimidation and bad faith, severely damaging David's legal position regarding child custody arrangements and the equitable distribution of all marital assets. Many individuals facing this exact marital dilemma mistakenly believe they can completely bypass these strict criminal statutes by simply hiring a licensed professional to do the dirty work. There is a widespread, incredibly dangerous myth that licensed private investigators possess special legal authority, vaguely similar to federal law enforcement agents, allowing them to legally place trackers wherever they deem necessary for an investigation. This is fundamentally and entirely false. A private investigator operates strictly under the exact same civilian privacy laws as the private citizen who hired them. If it is strictly illegal for David to track Emily's vehicle, it is equally illegal for David to pay a private investigator $5,000 to perform that exact same action on his behalf. If a private investigator breaks the law by trespassing on private property and installing a tracking device without the legally required ownership or explicit consent, both the investigator and the client who commissioned the illegal surveillance can and will face joint criminal prosecution. They will both face massive civil liability lawsuits for conspiracy to commit stalking and the intentional invasion of privacy. You absolutely cannot outsource illegal behavior to a third party to shield yourself from the legal consequences. The legal system views the individual financing the illegal tracking operation as heavily culpable as the individual who physically attached the magnet to the undercarriage in the dead of night. Understanding these foundational concepts of legal ownership and explicit consent is absolutely critical to protecting yourself from severe criminal liability and crippling civil lawsuits. However, even if you perfectly navigate the complex ownership requirements, even if your name is the only name printed on the legal title, and even if you operate strictly within the confines of your local county regulations, you are still facing a massive, hidden legal trap that completely destroys thousands of seemingly legal tracking operations every single year. The United States is not a single unified legal entity regarding electronic privacy and vehicle tracking. It is a highly fractured, heavily contradictory puzzle of 50 entirely different sets of complex state laws. Imagine you are a small business owner in a jurisdiction where tracking your company fleet is perfectly legal without ever notifying your employees. Your employee drives a company truck across a state border to deliver a package, completely unaware that the legal jurisdiction has instantly changed. By simply crossing an invisible geographical line on an interstate highway, your entirely legal asset management strategy may have just instantly transformed into a severe multi-state felony offense carrying mandatory prison time. The precise moment those tires cross the border, the rules of engagement are entirely rewritten, and the legal jeopardy becomes exponential. How exactly do these wildly conflicting state laws interact? Which specific states currently possess the most draconian anti-tracking statutes in the entire country? And how can a perfectly legal tracking operation suddenly trigger a massive federal law enforcement investigation? To comprehend how a perfectly legal tracking operation suddenly triggers a massive federal law enforcement investigation, we must completely dismantle the illusion that the United States operates under a singular, cohesive digital privacy framework. In the current year 2026, navigating the legal landscape of location data is incredibly treacherous precisely because you are dealing with 50 independent sovereign entities, each possessing its own fiercely guarded legal definitions of personal privacy, mechanical trespass, and electronic stalking. This chaotic legal patchwork means that your legal standing changes dramatically the exact second your vehicle tires roll across an invisible state border. What one state legislature heavily protects as a fundamental right of private property management, a neighboring state legislature aggressively prosecutes as a severe criminal invasion of personal privacy. To successfully navigate this environment without facing devastating potential outcomes, we must systematically analyze the extreme ends of this legal spectrum, examining both the most historically lenient jurisdictions and the most aggressively restrictive states in the entire country. Let us begin by examining the historical trends and stringent legal environment of California, a state that has consistently pioneered the most draconian and highly restrictive anti-tracking statutes in the nation. Under California Penal Code Section 637.7, the legislative framework is absolutely uncompromising. The statute explicitly dictates that no person or entity in this state shall use an electronic tracking device to determine the location or movement of a person. Notice the highly specific language utilized by the state legislature. The law does not merely prohibit tracking a vehicle you do not own. It fundamentally prohibits tracking a person. There is a specific narrow exception if the registered owner, lessor, or lessee of a vehicle has consented to the use of the electronic tracking device with respect to that vehicle. But even this exception is heavily burdened with immense legal peril. Imagine a business owner named Robert operating a highly successful logistics company based in Reno, Nevada. In Nevada, Robert has legally installed hardwired GPS telematics systems in his entire fleet of delivery trucks to optimize routing and monitor fuel efficiency, operating completely within his rights as the sole legal owner of the corporate vehicles. However, the exact moment one of Robert's drivers accepts a lucrative freight delivery crossing the border into Sacramento, California, Robert is instantly subjected to California jurisdiction. If Robert failed to secure explicit, legally documented consent from that specific employee to be tracked while operating within California state lines, Robert has just committed a misdemeanor offense under California law, punishable by the revocation of his business licenses, massive civil penalties, and potential jail time. The physical location of the monitoring computer screen in Nevada is entirely legally irrelevant. The crime occurs exactly where the physical tracking device transmits the signal. Now we must elevate the severity of this legal danger by introducing the devastating reality of federal jurisdiction. State boundaries do not merely separate differing local laws. They act as the ultimate legal trigger for catastrophic federal law enforcement intervention. When a civilian intentionally tracks a vehicle across state lines without authorization, they are no longer merely violating a local municipal code. They are actively engaging in interstate commerce, which immediately invites the scrutiny of the Federal Bureau of Investigation and the United States Department of Justice. This brings us to the severe implications of the federal interstate stalking statutes, specifically Title 18 of the United States Code, Section 2261A. Historical case studies demonstrate that federal prosecutors aggressively utilize this specific statute to target individuals who use electronic interactive computer services or electronic communication systems to travel across state lines with the explicit intent to kill, injure, harass, or place under surveillance with intent to kill, injure, harass, or intimidate another person. Consider a deeply concerning case study involving a private citizen named Sarah, residing in the state of New York in 2026. Sarah is currently navigating a highly volatile child custody dispute with her former partner. In a desperate, deeply misguided attempt to ensure her children are safely delivered to their scheduled weekend visitations, Sarah covertly hides a small magnetic cellular tracker inside the lining of her ex-partner's luggage, which is then placed inside his personally owned vehicle. Her former partner subsequently drives from New York, across the George Washington Bridge, and into the state of New Jersey. Sarah believes she is simply acting as a protective mother monitoring her children. The legal reality is that Sarah has just initiated a multi-state federal crime by utilizing a cellular network to actively monitor the location of a vehicle she does not legally own. And by having that monitored target cross a sovereign state border, federal prosecutors can completely bypass state-level privacy torts and immediately charge Sarah with a federal cyberstalking felony. The potential outcomes for Sarah include up to 5 years in federal prison for a first-time offense, completely obliterating any possibility of her ever securing physical custody of her children in family court. The federal legal system does not care about your personal motivations or your perceived justifications. It looks strictly at the unauthorized deployment of interstate electronic surveillance technology. Conversely, we must also examine jurisdictions that historically offer a far more lenient interpretation of property rights, such as Texas. In Texas, the Penal Code historically allows the installation of an electronic tracking device on a motor vehicle if you are the legal owner or lessee of that specific vehicle. This creates a massive false sense of security for thousands of residents. Many individuals misinterpret this statute as absolute legal immunity, mistakenly believing that as long as their name is on the title, they can track anyone, anywhere at any time. This is a fatal misunderstanding of the critical difference between criminal law and civil liability. Just because a local police department in Dallas tells you they will not press criminal charges for tracking a vehicle you physically own while your spouse is driving it, that absolutely does not protect you from being utterly financially destroyed in a civil courtroom. Civil courts operate on an entirely different standard of legal evidence and recognize severe civil torts, specifically the tort of intrusion upon seclusion. If a civil judge determines that your tracking operation was highly offensive to a reasonable person and severely violated the driver's expectation of privacy, you can be ordered to pay hundreds of thousands of dollars in punitive financial damages, completely independent of any criminal prosecution. You cannot simply rely on reading a single paragraph of a state penal code to protect your freedom and your financial assets. You must understand the intersection of criminal statutes, civil torts, and federal interstate commerce laws. But even if you somehow manage to perfectly navigate the complex web of vehicle ownership, secure the exact required consent, and maintain your tracking operation strictly within the borders of a legally favorable state, you are still completely exposed to another massive area of legal liability that almost everyone completely ignores. The physical installation process of the tracking device itself presents an entirely different set of severe criminal hazards. You see, attaching a magnetic battery box to a steel bumper is one thing, but modern tracking heavily relies on directly accessing the internal computer network of the vehicle. What specifically happens when you legally own the car, but you physically plug a GPS device directly into the onboard diagnostic port beneath the steering wheel? Are you simply powering a location beacon? Or are you technically committing a severe felony violation of the Federal Computer Fraud and Abuse Act by intentionally hacking into an automotive computer system without authorization? To answer that highly complex question, we must fundamentally shift our understanding of what a modern vehicle actually is in the current year 2026. A modern car is no longer merely a mechanical combustion engine attached to four wheels and a steel chassis. It is a highly sophisticated, rolling localized computer network. Every single time you press the brake pedal, roll down a power window, or adjust the digital climate control, you are sending complex digital commands through a central nervous system known as the Controller Area Network, or CAN bus. When a civilian purchases a commercially available GPS tracker designed to plug directly into the onboard diagnostics port, commonly known as the OBD2 port located directly beneath the steering column, they are making a physical data connection directly to this highly sensitive internal network. This specific action instantly elevates the legal jeopardy from a simple physical trespass to a highly complex digital intrusion. The Federal Computer Fraud and Abuse Act, a highly potent piece of legislation originally designed to aggressively prosecute international computer hackers and malicious cybercriminals, strictly prohibits intentionally accessing a protected computer without authorization or exceeding authorized access. The legal debate currently raging in federal appellate court centers entirely on whether plugging a third-party surveillance device into an automotive diagnostic port constitutes unauthorized access to a protected computer system. Consider a highly realistic case study involving a small logistics company operator named James, operating out of Chicago, Illinois. James decides to meticulously upgrade his fleet management system by purchasing a bulk order of advanced OBD2 telematics devices. These sophisticated modern trackers do not just report geographical location. They actively pull diagnostic data directly from the vehicle's internal computer, reporting engine revolutions per minute, exact fuel consumption, tire pressure, and even individual seatbelt usage. James legally owns the entire fleet of delivery vans, and his employees have signed standard employment contracts. James physically plugs these devices into the diagnostic ports of his entire fleet, fully believing he is simply executing a routine physical hardware upgrade to his own property. However, what James fails to realize is that the complex software operating the vehicle's internal computer network is proprietary technology owned exclusively by the automotive manufacturer. By plugging a third-party device into that port that actively interrogates the vehicle's computer modules, James might inadvertently be violating the strict terms of service embedded in the vehicle's original software licensing agreement. Furthermore, the Digital Millennium Copyright Act heavily restricts bypassing technological measures that control access to copyrighted works, which heavily includes automotive software. If the automotive manufacturer decides to pursue aggressive legal action, or if the inserted tracker accidentally introduces a software glitch that causes a catastrophic failure of the braking system on an active highway, James is no longer facing a simple civil privacy dispute. He is facing potential outcomes that include devastating federal civil liability for unauthorized computer access, severe breach of contract, and massive negligence claims that could entirely bankrupt his enterprise. The distinction between physically owning the hardware of the car and legally possessing the right to access its proprietary software network is incredibly thin and historically perilous. But let us escalate this scenario and deeply examine the physical installation methods that bypass the diagnostic port entirely, delving into the highly dangerous realm of covert hardwiring. Imagine an individual named Thomas, residing in the state of Florida, who strongly suspects his legally separated partner is actively concealing valuable financial assets. Thomas decides to bypass the easily discoverable OBD2 port and instead purchases a covert, professional-grade tracking device designed to be directly spliced into the vehicle's main electrical harness. Under the dark of night, Thomas accesses the interior fuse box of the vehicle, physically cuts into the primary power wires, and permanently solders the tracking device directly into the constant 12-volt power supply, hiding the module deep behind the plastic dashboard paneling. Thomas firmly believes that by ensuring the device is completely invisible to the naked eye, he is protecting himself from discovery and subsequent legal consequences. He has committed a fatal legal error. By physically altering the electrical architecture of a vehicle he does not exclusively own, Thomas has committed a severe physical trespass to chattels, which is a significant and highly actionable civil tort. Furthermore, because he intentionally destroyed or modified the physical property of another person by cutting the internal wiring harness, he can be immediately charged with criminal vandalism and malicious mischief, completely independent of any privacy violations associated with the actual tracking data. The physical act of installing the device becomes the primary, prosecutable criminal offense. Law enforcement does not even need to successfully prove that Thomas actively monitored the location data on his computer. The sheer physical evidence of the spliced wires and the illegally installed hardware is entirely sufficient to secure a criminal conviction and massive financial restitution. This physical installation hazard becomes exponentially more dangerous when we analyze the historical trends regarding rented and leased vehicles. A massive percentage of the American public currently drives vehicles they do not legally own, operating under complex, multi-year lease agreements governed by incredibly strict financial contracts. If you lease a luxury sedan and decide to covertly hardwire a GPS tracking device into the electrical system to monitor your teenage daughter's driving habits, you are directly violating the stringent anti-modification clauses buried deep within your lease agreement. When that vehicle is eventually returned to the dealership at the end of the lease term, certified mechanics will conduct a thorough, comprehensive inspection of the electrical harness. The immediate discovery of the spliced wires and the unauthorized tracking module will instantly trigger severe financial penalties. The dealership will charge you exorbitant, unavoidable fees to completely replace the compromised wiring harness, citing strict federal safety regulations and the immediate nullification of the manufacturer's warranty. The potential outcomes of tampering with leased property extend far beyond mere financial penalties. The leasing company can formally categorize the unauthorized installation as intentional property damage, permanently destroying your credit rating, and pursuing aggressive civil litigation to recover the total depreciated value of the entire vehicle. You are held entirely liable for every single cut wire and every single modified circuit. The legal environment surrounding the physical installation and digital integration of GPS tracking devices is an absolute minefield, heavily populated by federal cyber laws, strict property damage statutes, and complex software licensing agreements. You absolutely cannot simply attach a sophisticated piece of electronic surveillance equipment to a modern, highly computerized vehicle without potentially triggering a cascading avalanche of severe legal consequences. The courts are relentlessly establishing that the physical vehicle and its internal digital network are highly protected domains. However, while we have extensively analyzed the severe consequences of tracking a vehicle's physical location and interrogating its mechanical diagnostic data, we have not yet addressed the absolute most catastrophic legal error, a citizen can make in the entire realm of modern surveillance. Many of the highly advanced tracking devices currently available on the consumer market do not just transmit geographical coordinates. They possess hidden, highly sensitive internal microphones designed to actively record ambient audio inside the passenger cabin. What exactly happens when your illegally or even legally installed location tracker inadvertently captures a private, deeply personal phone conversation occurring inside the vehicle? You have just crossed the most heavily guarded legal boundary in the entire United States justice system, transitioning instantly from a localized privacy dispute directly into the terrifying realm of federal wiretapping and the strict interception of oral communications. How do state and federal authorities aggressively prosecute the unauthorized recording of human voices? And how can a simple location tracker instantly transform into a severe federal felony, carrying mandatory decades in federal prison? To bridge the gap between knowing a vehicle is parked at a specific address and actually hearing the conversations occurring inside that vehicle, we must dive directly into the deeply terrifying waters of the Federal Wiretap Act. Originally enacted decades ago to strictly govern the interception of telephone calls, this immensely powerful federal statute has been aggressively expanded over the years to cover almost all forms of modern electronic oral communication. The fundamental legal distinction here is absolute. When you track a vehicle's geographical location, you are gathering physical telemetry data based on public movements. But the exact second your tracking device begins actively recording ambient audio from within the passenger cabin of that vehicle, you are fundamentally intercepting a private, oral communication. Under the strict parameters of United States federal law, specifically Title 18 of the United States Code, Section 2511, intentionally intercepting any wire, oral or electronic communication without the legally required consent is a severe federal felony. This is not a minor privacy infraction or a simple civil dispute. The potential outcomes of a federal wiretapping conviction include massive, uninsurable financial fines and a mandatory statutory maximum of up to 5 years in federal prison for every single recorded conversation. The immense gravity of this situation cannot be overstated. Yet thousands of citizens routinely purchase advanced GPS tracking modules online, completely unaware that the tiny pinhole on the side of the plastic casing houses a highly sensitive, omnidirectional condenser microphone designed to capture whispers over the sound of highway road noise. The legal trap that completely destroys well-meaning individuals centers entirely on a massive, widespread public misunderstanding of state-level consent laws. You have likely heard the legal terms one-party consent and two-party consent casually thrown around in television shows or internet forums. In a one-party consent jurisdiction, federal and state laws dictate that only a single person involved in a conversation needs to grant legal consent for that conversation to be actively recorded. Conversely, in a two-party consent state, which is more accurately described as an all-party consent state, absolutely every single individual participating in the conversation must explicitly agree to the recording. This legal framework creates a catastrophic, life-altering blind spot for individuals utilizing modern tracking technology. The critical defining element of the one-party consent rule is that the person granting the consent must be an active, physical participant in the actual conversation being recorded. You absolutely cannot consent to recording a conversation that you are not actively participating in. When you place a live audio tracking device inside a vehicle and you are sitting miles away at your office desk listening to the feed, you are legally entirely absent from the communication. Therefore, you are capturing what the legal system formally categorizes as a zero-party consent recording. In every single jurisdiction across the entire United States, regardless of local state leniencies, a zero-party consent recording is universally prosecuted as an illegal, malicious wiretap. Let us deeply examine a specific, highly realistic case study to illustrate the absolute legal devastation caused by this technological misunderstanding. Imagine a man named Christopher residing in the state of Pennsylvania in the current year 2026. Pennsylvania is notoriously known as a strict two-party consent jurisdiction. Christopher is a highly protective father who legally owns a modern sport utility vehicle that his 19-year-old daughter routinely drives to her university classes. Deeply concerned about her recent associations and late-night activities, Christopher purchases a premium-tier cellular GPS tracker that specifically advertises a live remote audio monitoring feature. He discreetly hardwires this highly advanced device deep inside the center console of the vehicle, operating under the flawed assumption that because he holds the legal financial title to the car, he holds dominion over everything that happens inside it. One evening, his daughter is driving home with a close college friend sitting in the passenger seat. The windows are rolled up, the doors are locked, and they are driving down a dark, isolated interstate highway. Under established constitutional law, the interior of that sealed vehicle at that specific moment represents an immensely high, legally protected expectation of privacy. The two young women begin having a deeply personal, highly sensitive conversation regarding medical decisions and private familial matters. Miles away in his living room, Christopher activates the remote audio feature on his smartphone and silently listens to every single word. Christopher has just committed multiple severe felony offenses that carry life-destroying potential outcomes. By actively utilizing an electronic device to surreptitiously intercept a private oral communication where neither participating party granted explicit legal consent, he has directly violated both the Pennsylvania Wiretapping and Electronic Surveillance Control Act and the massive Federal Wiretap Act. If his daughter's friend subsequently discovers this device and reports the incident to state or federal law enforcement authorities, Christopher is facing immediate, catastrophic legal ruin. The local district attorney will aggressively pursue criminal prosecution, potentially resulting in years of mandatory state incarceration. Furthermore, the friend can immediately launch a devastating federal civil rights lawsuit against Christopher under the civil remedies provision of the Federal Wiretap Act, seeking massive statutory damages, punitive financial penalties, and full reimbursement of all exorbitant legal fees. The undeniable fact that Christopher is the legal owner of the physical vehicle provides absolutely zero legal defense against the felony interception of human voices. The judicial system meticulously separates the legal ownership of the physical metallic space from the fundamental human right to hold a private conversation free from covert electronic eavesdropping. This exact same catastrophic legal principle firmly applies even in states historically known for highly relaxed privacy statutes. Imagine a woman named Amanda currently navigating a highly contentious divorce proceeding in the state of Texas in 2026. Texas operates strictly as a one-party consent state. Amanda secretly places an audio-enabled tracking beacon beneath the passenger seat of her husband's solely owned pickup truck, actively hoping to gather audio evidence of financial infidelity to leverage during the upcoming mediation hearings. Amanda mistakenly believes that the Texas one-party consent law provides a blanket shield of legal immunity for her surveillance activities. This is a fatal misinterpretation of the state penal code. When Amanda remotely activates the microphone and listens to her husband speaking on his cellular phone with his legal defense attorney, she is not a party to that conversation. She is an unauthorized third party intercepting a highly privileged, legally protected oral communication. Despite residing in a notoriously lenient one-party consent jurisdiction, Amanda has instantly committed a severe state jail felony for illegal wiretapping. Any audio recordings she manages to capture are strictly completely inadmissible in family court, and the presiding judge will likely refer her directly to the county prosecutor for immediate criminal indictment. The rapid, terrifying evolution of consumer technology continues to blur these perilous legal lines at an alarming rate. We are no longer merely discussing standalone, battery-powered magnetic boxes purchased from obscure surveillance websites. The modern automotive landscape of 2026 is completely saturated with heavily integrated, multi-lens smart dashcams, sophisticated driver monitoring systems, and highly advanced aftermarket alarm systems that continuously record high-definition video and crystal-clear internal audio by default. Many vehicle owners install these heavily marketed consumer devices specifically for insurance liability protection in the event of a traffic collision, completely failing to recognize the severe legal liability they are actively creating for themselves the exact moment they lend their vehicle to a friend, a coworker, or a family member. If your perfectly legal, forward-facing safety dashcam silently records a private conversation between two borrowing drivers without their explicit, legally documented knowledge and consent, you are technically operating an illegal wiretap every single time that vehicle leaves your driveway. You must fundamentally understand that the United States legal system heavily protects the human voice with a level of ferocity that completely eclipses the legal protection of a vehicle's geographical coordinates. But while we have extensively covered the severe dangers of covert civilian tracking and the catastrophic legal pitfalls of unauthorized audio recording, we are about to enter an entirely different, heavily obscured dimension of location privacy that operates entirely outside the realm of aftermarket consumer electronics. What exactly happens when the tracking device is not placed on your vehicle by a suspicious spouse, a paranoid employer, or a local private investigator, but is instead meticulously engineered and permanently physically embedded deep within the vehicle's core architecture by the automotive manufacturer themselves on the factory assembly line. How are massive, multi-billion-dollar corporate data brokers actively harvesting your highly precise location data, your aggressive driving habits, and your daily commuting routines straight from your vehicle's native computer system? And more importantly, how are they legally allowed to sell that deeply private information to the highest bidder without ever explicitly asking for your permission? To answer that alarming question, we must completely pivot our focus from the aftermarket devices magnetically attached to a bumper and examine the fundamental architecture of the modern automobile itself. In the current year 2026, the concept of a disconnected, mechanically isolated vehicle is entirely extinct. When you purchase a new vehicle off a dealership lot today, you are not merely buying a mode of transportation. You are purchasing a rolling multi-ton smartphone equipped with a permanent, high-speed cellular data connection. Deep within the dashboard of almost every single modern vehicle manufactured in the last decade lies a sophisticated piece of hardware known as the telematics control unit. This highly advanced module possesses its own dedicated cellular modem, its own internal GPS receiver, and direct, unfiltered access to the vehicle's central computer network. Unlike the battery-powered trackers we previously discussed, which can be physically discovered and removed, this factory-installed hardware is permanently integrated into the vehicle's core electrical architecture. If you attempt to disable or violently remove the telematics control unit, the vehicle will likely instantly immobilize itself, severely limiting your ability to even start the engine. The automotive manufacturers have fundamentally engineered a reality where participating in this massive surveillance network is mandatory for the vehicle to function. Let us deeply examine exactly how this catastrophic loss of privacy is legally justified through a highly realistic case study. Imagine a man named Marcus who decides to purchase a brand new, highly rated crossover sport utility vehicle for his daily commute in 2026. Marcus spends 4 exhausting hours at the dealership negotiating the financing, reviewing the warranty options, and signing a massive stack of digital documents on a tablet computer. Within that dense, deliberately confusing mountain of digital paperwork is an immensely critical legal document known as the End User License Agreement, commonly referred to as the EULA, alongside a highly detailed, intentionally complex privacy policy. When Marcus hastily taps his finger on the screen to accept the terms and finalize the vehicle purchase, he unknowingly executes a legally binding contract that grants the automotive manufacturer explicit, irrevocable permission to harvest, store, analyze, and distribute his highly personal telemetry data. The legal trap is perfectly set. Marcus assumes he is merely signing the financial loan agreement and the vehicle registration, completely oblivious to the fact that he has just authorized a massive multinational corporation to monitor his every single movement. The manufacturer legally shields themselves by burying this consent deep within hundreds of pages of legal jargon, fully aware that no reasonable consumer possesses the legal expertise or the sheer stamina to read and negotiate every single line item before driving the vehicle off the lot. The sheer volume and hyper-granular precision of the data actively harvested by these factory-installed systems are genuinely staggering. This is not merely a system logging the physical address where you park at night. The vehicle's native computer system continuously records highly specific behavioral telemetry. It logs the exact millisecond you aggressively accelerate onto a highway on-ramp, the precise gravitational force of a hard braking event at a red light, the exact speed you maintain on rural backroads, the specific geographic coordinates of your routine stops, and even whether or not your seatbelt was securely fastened during a specific driving maneuver. All of this highly sensitive, deeply personal data is immediately transmitted through the vehicle's permanent cellular connection to massive, heavily fortified cloud servers managed directly by the automotive manufacturer. But the deeply invasive surveillance operation does not stop at the manufacturer's server farms. This is where we must examine the heavily concealed, multi-billion-dollar industry of third-party data brokers and the severe potential outcomes for the average consumer. Historical trends extensively document that automotive manufacturers actively partner with massive, global data clearinghouses. These massive corporate entities specialize in aggregating consumer data from thousands of disparate sources. The automotive manufacturer packages Marcus's highly specific driving telemetry into massive data sets and quietly sells it to these brokers for an enormous profit. The data broker then fundamentally analyzes Marcus's driving habits, assigning him a highly specific, proprietary risk score based entirely on his geographic locations, his acceleration patterns, and his braking history. Who precisely is the ultimate buyer of this secretly harvested risk score? It is Marcus's own auto insurance provider. Imagine the shock and devastation Marcus experiences when he receives his auto insurance renewal notice 6 months later, only to discover that his monthly premiums have suddenly skyrocketed by an astonishing 40%. Marcus has not received a single traffic citation, he has not been involved in any physical collisions, and his financial credit score remains pristine. However, his insurance provider has quietly purchased his driving dossier from the data broker and mathematically determined that Marcus represents a significantly higher statistical risk due to his tendency to brake harshly during his daily commute and his frequent late-night trips to specific geographic zones. Marcus is completely powerless to fight this massive financial penalty because the underlying data is entirely legally sourced. By simply tapping accept on the dealership tablet, Marcus legally authorized the manufacturer to sell his data, he legally authorized the data broker to analyze his habits, and he legally authorized his insurance company to adjust his rates based on third-party telematics data. The entire ecosystem of surveillance and financial penalization operates perfectly within the established boundaries of corporate contract law, entirely without Marcus ever installing an aftermarket tracking device or actively consenting to a specific insurance tracking program. The automotive industry heavily attempts to justify this massive privacy intrusion by aggressively claiming that the data sold to these brokers is thoroughly anonymized, theoretically stripped of personally identifiable markers like Marcus's name or his specific vehicle identification number. However, extensive technological case studies have repeatedly and conclusively proven that anonymized location data is a complete mathematical myth. When a data broker possesses a continuous, highly precise digital log of a vehicle leaving a specific residential driveway every single morning at exactly 7 o'clock, parking at a specific corporate office building downtown all day, and returning to that exact same residential driveway every evening, the identity of the driver is instantly mathematically obvious. The unique, highly individualized mosaic of a human being's daily movements acts as a perfect, undeniable digital fingerprint. The legal system currently allows these corporations to hide behind the extremely flimsy shield of pseudo-anonymization, leaving consumers highly vulnerable to massive financial exploitation and total behavioral profiling. You might currently be thinking that while having your auto insurance arbitrarily doubled based on secret telemetry data is a terrible financial burden, it is ultimately just a matter of corporate greed and civil consumer rights. But what exactly happens when this massive centralized reservoir of highly precise, continuously updated location data catches the attention of entities that possess the power to permanently revoke your physical freedom? If the automotive manufacturers and the massive third-party data brokers possess full, unfettered legal access to this highly granular, deeply sensitive location data, what exactly happens when local, state, or federal law enforcement agencies decide they actively want that exact same data without going through the tedious, highly restrictive process of securing a traditional judicial search warrant from a judge? How does the terrifying legal concept known as the third-party doctrine completely and utterly obliterate your fundamental Fourth Amendment constitutional rights, when your very own vehicle essentially acts as a permanent, cooperating witness against you in a major criminal investigation? To fully comprehend the sheer destructive power of the third-party doctrine, we must first examine the foundational bedrock of American privacy law and how modern technology has completely bypassed it. For decades, the Fourth Amendment has served as a critical shield, theoretically protecting citizens from unreasonable searches and seizures. If a police detective wanted to rifle through your filing cabinet or physically attach a tracking device to your bumper, as we discussed in the landmark Jones decision, they absolutely had to stand before a sworn judge, present hard evidence of probable cause, and secure a highly specific search warrant. But the third-party doctrine, a legal precedent established by the Supreme Court in the late 20th century, created a massive, devastating loophole that law enforcement agencies currently exploit on a daily basis in the year 2026. This doctrine fundamentally states that if you voluntarily provide your private information to a third party, such as a bank, an internet service provider, or an automotive manufacturer, you legally forfeit any reasonable expectation of privacy regarding that specific information. The government no longer needs a strict probable cause warrant to obtain it, they simply need a basic administrative subpoena, which requires significantly less legal justification, or in many modern instances, they simply open their checkbook and purchase the data outright from the very same commercial data brokers your car manufacturer just sold it to. Imagine a highly concerning case study involving a citizen named Daniel residing in Ohio. Daniel is a completely law-abiding citizen who recently purchased a modern, fully connected pickup truck. Unbeknownst to Daniel, A string of highly sophisticated commercial burglaries has been plaguing his local county. The local police department is under immense political pressure to solve these crimes, but they lack physical evidence, eyewitnesses, or any primary suspects. Instead of conducting traditional, labor-intensive detective work, the lead investigators utilize a controversial digital dragnet tactic known as a geofence warrant, heavily relying on the third-party doctrine. They serve a sweeping legal demand to the major automotive data brokers, demanding the precise location data, including vehicle identification numbers and native GPS coordinates, of absolutely every single connected vehicle that was physically present within a 2-mile radius of the burgled businesses during specific late-night hours over the past 3 months. Because Daniel suffers from severe insomnia and routinely takes late-night drives to clear his head, his brand-new pickup truck was frequently pinging the cell towers near those exact commercial zones. Daniel is entirely innocent, yet his vehicle's factory-installed telematics unit has just placed him squarely at the center of a major criminal investigation. The police did not need to prove Daniel did anything wrong to acquire his location history. By simply signing the terms of service at the dealership, Daniel technically handed his location data to a third-party corporation, instantly stripping that data of its Fourth Amendment constitutional armor. Law enforcement receives a massive spreadsheet from the data broker, highlighting Daniel's vehicle as a statistical anomaly. The potential outcomes for Daniel are absolutely terrifying. He is suddenly subjected to intense police surveillance, his workplace is visited by detectives, and he is forced to hire an expensive criminal defense attorney simply to prove he was merely driving aimlessly to combat a sleep disorder. The vehicle he pays $1,000 a month to finance essentially became a highly efficient, completely silent informant for the state. The legal friction surrounding this exact scenario is currently generating historic battles in federal appellate courts across the nation. Privacy advocates aggressively argue that the Supreme Court decision in Carpenter v. United States, which ruled that the government requires a warrant to access historical cell site location information from wireless carriers, should logically extend to the massive troves of telematics data generated by modern vehicles. They argue that a modern car is functionally indistinguishable from a smartphone in terms of its ability to generate an intimate, continuous mosaic of a person's entire life. However, state prosecutors and federal agencies vehemently push back, utilizing historical trends to argue that driving on public roads is a heavily regulated privilege, not a fundamental constitutional right, and therefore, the highly detailed mechanical and locational data generated by the vehicle itself does not warrant the same strict legal protections as a personal mobile device. They argue that when you connect your vehicle to a commercial cellular network to enjoy live traffic updates or remote start capabilities, you are actively choosing commercial convenience over constitutional privacy. But the legal nightmare deepens significantly when we examine situations where law enforcement completely bypasses the judicial system altogether. We must confront the deeply unsettling reality of government agencies utilizing taxpayer funds to directly purchase commercial datasets. Federal agencies have been heavily documented circumventing the warrant requirement entirely by simply acting as a commercial client. If a private data broker can legally buy the GPS history of your sedan from the manufacturer, and that broker is legally permitted to sell that data on the open market, there is currently very little federal law preventing a government agency from simply purchasing that exact same data subscription. This creates an unregulated, heavily commercialized surveillance state. Imagine a scenario where a federal agency is tracking a specific political protest or a controversial public gathering. Instead of establishing probable cause to monitor specific individuals, the agency simply purchases the bulk telematics data for that specific geographical grid for that exact afternoon. They instantly possess the driving speeds, the parking locations, and the precise identities of thousands of citizens exercising their First Amendment rights, all completely legally obtained through a massive loophole in the third-party doctrine. You are no longer protected by a judge demanding evidence of a crime. Your privacy is entirely dependent on the specific privacy policy of the corporation that manufactured your dashboard. This incredibly dangerous fusion of corporate data harvesting and unverified government access creates an environment where your physical vehicle is arguably the greatest threat to your personal privacy. But incredibly, the native GPS system hidden deep inside your dashboard is only one half of the modern surveillance equation. While we have extensively analyzed the data your car transmits out to the world, we must now pivot to examine the deeply intrusive technology that actively scans, captures, and logs your vehicle from the outside in. You might successfully disable your car's internal modem. You might drive an older mechanical vehicle from the 1990s specifically to avoid corporate tracking, and you might legally own the vehicle outright. But absolutely none of those protective measures will save you from the massive, invisible grid of millions of high-speed optical sensors currently blanketing American highways, intersections, and neighborhood streets. These advanced cameras do not need your consent, they do not care about the third-party doctrine, and they are capturing your exact location hundreds of times a day without you ever noticing. How exactly do automated license plate readers fundamentally bypass every single privacy law we have discussed so far? And how has this billion-dollar network essentially transformed every public road in the United States into a mandatory, highly unconstitutional digital checkpoint? To completely understand this terrifying paradigm shift, we must look directly at the rapidly expanding infrastructure of automated license plate readers, commonly referred to as ALPR systems. Historically, these systems were bulky, wildly expensive cameras strictly mounted to the trunks of dedicated highway patrol vehicles or bolted above major toll booths. However, historical trends over the last decade have completely revolutionized this technology. By the current year 2026, ALPRs have evolved into hyper-advanced, solar-powered, artificial intelligence-driven optical sensors that are no larger than a shoebox. They are quietly strapped to utility poles, bolted to residential stop signs, hidden inside highway construction barrels, and integrated into the architecture of standard traffic lights. These cameras do not simply snap a blurry photograph of your license plate. They utilize highly sophisticated machine learning algorithms to instantly capture, categorize, and cross-reference an immense amount of vehicular data in a fraction of a second. As your vehicle passes through the camera's field of view, the system instantly logs your alphanumeric license plate, the specific make, the specific model, the exact factory paint color, any unique identifying marks such as aftermarket roof racks or specific bumper stickers, and precisely timestamps your exact geographic coordinates. In many modern iterations, high-definition infrared sensors are powerful enough to capture the silhouettes and basic facial geometry of the driver and front seat passenger, regardless of the time of day or the darkness of the night. The legal justification allowing this massive, invisible dragnet to exist operates entirely on a single, heavily debated judicial concept regarding the exterior of your vehicle. The courts have historically maintained that because the government explicitly mandates you to prominently display a standardized, highly reflective license plate on the exterior of your vehicle as a strict condition of driving on public roads, you inherently possess absolutely zero reasonable expectation of privacy regarding that specific numeric sequence. Because your license plate is completely visible to any random pedestrian standing on a public sidewalk, law enforcement agencies argue that utilizing a computer to read that same plate is not fundamentally a search under the Fourth Amendment. It is merely the automated observation of public space. But this argument deliberately ignores the terrifying reality of mass-scale data aggregation. A single police officer observing your vehicle passing through an intersection is a random, isolated event. But a synchronized network of 10,000 interconnected cameras tracking your vehicle through multiple counties, across state lines, and precisely mapping your route from your home to your medical clinic, your workplace, and your political gatherings creates the exact same invasive digital mosaic of your life that the Supreme Court explicitly warned against in previous historical case studies. The true nightmare scenario, however, does not merely involve government-owned cameras. The most massive and rapid expansion of ALPR technology in the United States is currently being driven entirely by private entities. Imagine a citizen named Jessica residing in a quiet, heavily populated suburban neighborhood in the year 2026. Recently, Jessica's local homeowners association held a brief meeting and voted to install a network of privately owned ALPR cameras at every single entrance and exit of the subdivision, citing neighborhood security and property value protection. Jessica assumed these cameras were simply recording video to a local hard drive in case of vandalism. She is entirely unaware of the massive unconstitutional data sharing agreements happening behind the scenes. The private technology companies that manufacture and install these suburban cameras often heavily subsidize the hardware costs by retaining the absolute legal right to aggregate and sell the captured location data. Every single time Jessica leaves for work, drops her children off at school, or returns home late at night, that highly precise location data is instantly uploaded to a massive, centralized commercial database. This privately owned database acts as the ultimate loophole for law enforcement agencies. If a local police department wants to track a suspect but lacks the required probable cause to secure a judicial warrant for cellular location data, they simply log into a subscription-based portal provided by the private ALPR company. Because the cameras are technically owned by the homeowners association, and the data is voluntarily aggregated by a private corporation, the police can search the historical location data of billions of recorded vehicle sightings completely without a warrant. Jessica has been seamlessly integrated into a national surveillance grid simply by driving into her own driveway. Her highly sensitive daily routine is fully accessible to thousands of federal, state, and local law enforcement officers across the country, all completely bypassing any traditional judicial oversight or constitutional legal friction. Furthermore, we must thoroughly examine the severe potential outcomes generated by the active, real-time deployment of this technology, specifically regarding the highly controversial law enforcement hot list. Every time an ALPR camera captures a plate, that number is instantly bounced against massive federal and state databases of stolen vehicles, outstanding felony warrants, and suspended licenses. If the computer algorithm detects a match, it immediately generates a high-priority alert to all active patrol units in the surrounding geographical area. But artificial intelligence optical character recognition is profoundly flawed. Historical case studies are densely populated with terrifying incidents where a dirty camera lens, a heavy rainstorm, a partially obscured state logo, or a simple algorithmic miscalculation causes a camera to incorrectly read a license plate number. An innocent citizen driving home from the grocery store is suddenly surrounded by multiple police cruisers, subjected to a high-risk felony traffic stop with drawn firearms, and violently detained on the side of a busy highway, entirely because a private camera mistakenly read the letter B as the number 8. The burden of proof instantly shifts to the terrified citizen, who must frantically prove their identity and the legal ownership of their vehicle while staring down the barrel of a loaded weapon, all due to an unregulated, completely automated machine error. The sheer volume of innocent citizens swept up in this automated surveillance dragnet is mathematically staggering, largely because the United States possesses almost no unified legal framework regulating exactly how long these private companies and police departments are allowed to retain your location data. If you drive past a privately owned ALPR camera in certain strict jurisdictions, that data might be legally mandated to be purged within 30 days if your vehicle is not actively linked to an ongoing criminal investigation. But if you drive that exact same vehicle across a state border into a heavily unregulated jurisdiction, that exact same photograph, timestamp, and location ping can be legally stored on a commercial server for up to 5 years. The compilation of 5 years of your precise daily movements is a horrifyingly potent weapon. It can completely reveal your religious affiliations based on where you park on Sunday mornings, your medical history based on the specialized clinics you visit, and your deeply personal relationships based on the residential driveways you frequent late at night. We have completely established that the modern American roadway is an absolute minefield of corporate telemetry data, factory-installed digital spies, and highly sophisticated optical surveillance networks capturing your every move. It is entirely understandable that after learning the true horrifying extent of this inescapable digital dragnet, many citizens feel a desperate, overwhelming urge to aggressively fight back. The internet is absolutely flooded with forums and underground marketplaces selling specialized GPS signal jammers, reflective license plate covers, algorithmic scrambling devices, and complex hardware modifications designed to completely blind the surveillance state and reclaim a sense of fundamental physical privacy. But before you decide to purchase a highly illegal signal blocker or attempt to actively sabotage the telematics unit buried in your dashboard, you must understand that the legal system has anticipated this exact rebellion. What exactly happens when an ordinary citizen attempts to deploy active electronic countermeasures against the surveillance grid? And how can attempting to reclaim your own privacy instantly trigger the most devastating, aggressive federal criminal charges we have discussed in this entire masterclass? To answer that critical question, we must venture into the highly clandestine world of electronic countermeasures and the catastrophic legal miscalculations citizens make when attempting to forcibly reclaim their digital privacy. When individuals discover the sheer magnitude of the location data being harvested from their daily lives, the immediate psychological reaction is often a desperate scramble for a technological cure. A brief internet search will instantly reveal countless offshore websites aggressively marketing active GPS jammers, signal blockers, and frequency scramblers. These devices are often no larger than a standard universal serial bus thumb drive, designed to plug directly into a vehicle's 12-volt power outlet. The marketing materials heavily suggest that by simply activating this inexpensive piece of hardware, a driver can instantly cloak their vehicle in an impenetrable bubble of electronic invisibility, completely severing the connection between the dashboard telematics unit and the orbiting constellation of navigation satellites. However, this is a devastating and highly illegal illusion. Operating a GPS jammer within the United States is not merely a localized traffic infraction or a minor civil dispute. It is an incredibly severe federal crime that directly violates the core provisions of the Communications Act of 1934. The fundamental problem with jamming technology is that radio frequencies do not politely respect the physical boundaries of your vehicle. A jammer operates by aggressively broadcasting massive amounts of localized radio frequency noise on the exact same spectral bands utilized by legitimate GPS signals, effectively deafening any receiving device in the immediate vicinity. But that vicinity extends far beyond your own dashboard. Let us deeply examine a highly realistic case study to illustrate the terrifying potential outcomes of deploying this technology. Imagine a citizen named Robert operating a commercial delivery truck in the year 2026. Robert is deeply frustrated by his employer's microscopic micromanagement of his daily routes via a hardwired fleet tracking system. To secure a few hours of unmonitored breaks, Robert purchases a $50 GPS jammer online and activates it in his truck cabin. Robert believes he is engaging in a harmless, victimless act of corporate rebellion. However, Robert's delivery route takes him directly past a major metropolitan airport and a regional medical center. The highly powerful radio frequency noise emitting from Robert's truck instantly bleeds into the surrounding airspace. He inadvertently blinds the highly sensitive GPS navigation systems of commercial airliners attempting final approach, and simultaneously knocks out the localized dispatch routing systems of active emergency medical ambulances. The federal government treats this level of infrastructural interference as a massive, high-priority threat to national security. The Federal Communications Commission possesses highly advanced, vehicle-mounted radio direction finding equipment specifically designed to actively hunt down unauthorized signal interference. Historical trends demonstrate that federal agents will rapidly deploy to the affected grid, triangulate the exact source of the jamming signal, and intercept the offending vehicle. The potential outcomes for Robert are absolutely catastrophic. The Federal Communications Commission can levy immediate civil forfeitures, easily exceeding $100,000 for a single violation. Furthermore, Robert faces imminent federal criminal prosecution for the willful and malicious interference with authorized radio communications, which carries the potential for years in federal prison, the immediate permanent seizure of his vehicle, and the total destruction of his professional livelihood. Attempting to block a corporate tracker instantly elevated Robert to the status of a federal criminal, actively sabotaging critical aviation infrastructure. Faced with the terrifying reality of federal jamming laws, many citizens attempt to pivot their defensive strategies toward defeating the exterior optical surveillance grid, specifically the automated license plate readers we previously analyzed. The consumer market is flooded with passive physical countermeasures, including highly reflective aerosol sprays designed to overexpose infrared camera lenses, polarized plastic plate covers that completely obscure the alphanumeric characters when viewed from an angle, and aftermarket license plate frames embedded with high-intensity infrared light-emitting diodes designed to completely blind the automated optical sensors. While these physical modifications do not broadcast illegal radio frequencies, they directly violate incredibly strict state vehicle codes in virtually every single jurisdiction across the country. Imagine a driver named Sarah residing in Texas who installs a heavily tinted, polarized license plate cover on her personal sedan specifically to evade the privately owned surveillance cameras installed throughout her neighborhood. Sarah mistakenly believes she has discovered a legally clever loophole. However, the legal mandate to maintain a clearly legible, entirely unobstructed license plate is an absolute cornerstone of state motor vehicle law. When a highway patrol officer observes Sarah's obscured plate, they instantly possess the necessary reasonable suspicion to initiate a formal traffic stop. The potential outcomes of this encounter escalate rapidly. In many jurisdictions, the intentional deployment of a device specifically designed to evade electronic toll collection or optical surveillance is categorized as a severe misdemeanor offense. The officer can immediately impound Sarah's vehicle, physically confiscate the illegal plate cover as criminal evidence, and issue massive financial citations. Furthermore, the deliberate attempt to conceal the vehicle's identity frequently triggers a heightened level of law enforcement scrutiny, often providing the legal justification required for a comprehensive, invasive physical search of the entire vehicle. When citizens realize that active jamming invites federal agents and passive covers invite immediate traffic stops, they frequently resort to the most dangerous and legally complex countermeasure of all, which is the direct, physical sabotage of the vehicle's internal factory hardware. Online automotive forums are densely populated with highly risky, step-by-step instructions detailing exactly how to dismantle a modern dashboard, locate the telematics control unit, and physically sever the cellular antenna wires or completely remove the localized subscriber identity module card. Individuals execute this physical destruction believing they are simply exercising their fundamental right to modify their own personal property. However, the modern automotive architecture of 2026 is a highly integrated, deeply intertwined ecosystem. The communications module you are actively attempting to destroy is rarely an isolated system. It is fundamentally hardwired into the vehicle's most critical safety infrastructure, including the supplemental restraint system and the automated emergency crash notification network. Consider a catastrophic scenario involving a young driver named David, who meticulously follows an online tutorial to physically sever the cellular antenna of his brand new sport utility vehicle, successfully stopping the manufacturer from harvesting his daily location data. Months later, David is involved in a severe, high-speed collision on a remote, isolated rural highway late at night. The airbags deploy perfectly, but because David intentionally destroyed the telematics communication link, the vehicle is completely unable to transmit the automated emergency SOS signal to local first responders. David is left severely injured and stranded for hours simply because he physically sabotaged his own safety net. The devastating consequences extend far beyond physical safety and directly into absolute financial ruin. When David's auto insurance company conducts their mandatory post-collision mechanical investigation, their forensic technicians will immediately discover the intentionally severed wires and the deliberate tampering with the vehicle's integrated safety systems. By purposefully altering factory-installed safety equipment, David has directly violated the strict terms of his insurance policy. The insurance provider possesses full legal authority to completely deny his massive medical claims, entirely refuse to cover the total loss of the vehicle, and instantly cancel his coverage for intentional hardware tampering and extreme liability negligence. Furthermore, if the vehicle was actively leased or financed, the lending institution will immediately declare a critical breach of contract, demanding the full remaining balance of the vehicle instantly due, effectively bankrupting David over a severed wire. The incredibly harsh reality of the year 2026 is that every single technological attempt to forcefully blind the modern surveillance grid, whether through active radio jamming, physical optical obstruction, or destructive hardware sabotage, carries immense, life-altering legal and financial risks that far outweigh the perceived privacy benefits. You cannot simply hack, spray, or cut your way out of this massive corporate and governmental data dragnet without stepping directly into a severe legal trap. But this terrifying realization begs the ultimate, most important question of this entire masterclass. If you absolutely cannot use technology to fight back against this surveillance, and if the manufacturers and data brokers are legally entrenched in their right to harvest your life, how do you actually protect yourself? What are the legitimate, highly obscure, court-approved legal mechanisms, the hidden manufacturer opt-out clauses, and the specific state privacy acts that currently allow a citizen to legally scrub their data, successfully revoke their consent, and systematically vanish from the digital grid without ever committing a single federal felony? To completely reclaim your digital privacy without risking catastrophic federal prosecution or voiding your primary automotive insurance, you must transition your defensive strategy away from crude physical sabotage and directly into the highly complex, entirely legal realm of administrative revocation and strict statutory compliance. The automotive manufacturers and massive data brokers operate heavily on the fundamental assumption of consumer apathy. They deliberately construct their legal frameworks believing that less than 1% of the American public possesses the required stamina to actively navigate their labyrinthine opt-out procedures. By understanding exactly how to weaponize their own corporate terms of service against them, you can legally sever the data pipeline without ever touching a single wire inside your vehicle. The very first, most critical legal mechanism at your disposal is the formal revocation of connected services. When you purchase a modern vehicle in the year 2026, the dealership legally enrolls you in a proprietary telematics program, often marketed under incredibly benign-sounding names like Smart Assist or Connected Care. These programs are precisely the digital bridge transmitting your location data to corporate servers. However, buried deeply within the hundreds of pages of the end-user license agreement is a federally mandated clause that legally requires the manufacturer to provide an avenue for consumers to unilaterally terminate these services. Imagine a highly vigilant consumer named Andrew, who recently purchased a sophisticated luxury sedan. Instead of attempting to rip the dashboard apart, Andrew executes a completely legal, administrative blockade. He immediately contacts the automotive manufacturer's dedicated privacy division, bypasses the standard dealership salespeople who lack the authority to alter data contracts, and formally demands the total deactivation of all two-way cellular telematics. Andrew insists on receiving legally binding, written confirmation that the vehicle's internal modem has been administratively disabled at the carrier level. By executing this precise maneuver, Andrew successfully neutralizes the data transmission without physically destroying the hardware, meaning his warranty remains perfectly intact, and he has committed absolutely zero federal violations. The potential outcomes of this strategy are profoundly protective, legally isolating the vehicle's internal computer from the external corporate cloud, while maintaining complete compliance with all state and federal regulations. However, simply stopping the future flow of data is entirely insufficient if you wish to truly vanish from the digital grid. You must actively hunt down and aggressively scrub the massive historical archives of location data that the corporations have already harvested and sold. This brings us directly to the immense power of modern state privacy legislation, which has fundamentally transformed the landscape of digital ownership in the United States. If you reside in a jurisdiction with aggressive, consumer-forward privacy frameworks, such as the California Privacy Rights Act or the highly expansive Virginia Consumer Data Protection Act currently enforced in 2026, you possess terrifying legal leverage over these massive data brokers. These comprehensive privacy laws grant citizens the absolute legal right to submit a formal data subject access request. Consider a detailed case study involving a citizen named Rebecca who discovers her daily commuting routines have been secretly compiled and sold to her automotive insurance provider, resulting in a massive premium increase. Because Rebecca resides in a protected legal jurisdiction, she drafts a formal, legally binding data subject access request and submits it directly to both the vehicle manufacturer and the specific third-party data clearinghouses involved in the transaction. Under the strict statutory requirements of these privacy acts, the corporations are not merely requested to comply, they are legally mandated under the threat of crippling state-level financial penalties to fully disclose exactly what data they possess regarding Rebecca, explicitly identify every single third party they have sold that data to, and most importantly, they must permanently, irreversibly delete every single localized coordinate linked to her specific profile upon her direct command. Furthermore, these acts mandate a strict do not sell my personal information legal mechanism. By actively utilizing these state-provided legal tools, Rebecca legally forces a massive multinational corporation to completely purge her driving history from their commercial servers, effectively scrubbing her digital footprint entirely through the power of administrative law, rather than illegal hardware tampering. But what happens if you reside in a state that has historically refused to enact these comprehensive privacy protections? You are not completely defenseless. You must aggressively pivot your strategy to target the third-party data aggregators directly through federal consumer protection frameworks, specifically utilizing the Fair Credit Reporting Act. While this massive federal statute is historically associated with standard financial credit scores, aggressive legal challenges and evolving historical trends have forced the courts to recognize that highly detailed telematics profiles utilized to determine auto insurance rates fundamentally operate as consumer reports. Imagine a driver named Christopher living in a highly deregulated state. He legally demands his complete consumer disclosure file from the major data exchanges specializing in automotive telematics. When Christopher receives a 70-page document meticulously detailing every single hard-braking event and highway speed he generated over the past 4 years, he exercises his federal right to aggressively dispute the accuracy of that data. Because the optical sensors and internal computer modules are notoriously prone to calibration errors and algorithmic hallucinations, Christopher forces the data broker to launch a formal, legally mandated investigation into the mechanical validity of every single data point. When the data broker inevitably fails to provide absolute, undeniable mechanical proof of accuracy for every logged event within the strict 30-day federal timeline, they are legally compelled by federal law to completely delete the disputed driving data from his permanent profile. Christopher successfully weaponizes a decades-old federal financial statute to completely dismantle a modern digital surveillance file. For those individuals who demand absolute, physical certainty that their vehicle is incapable of transmission, the legal landscape of 2026 provides a highly specific, thoroughly protected pathway through the rapidly expanding right to repair legislative framework. Instead of recklessly cutting wires in your driveway and committing a felony, historical trends show highly informed citizens actively seeking out specialized, legally certified independent automotive technicians. These licensed professionals possess the proprietary software tools, the advanced engineering schematics, and the explicit legal authority to safely isolate the telematics control unit from the primary communication network without compromising the critical supplemental restraint systems or violating strict federal emission tampering laws. By utilizing a certified professional operating under the legal umbrella of right to repair mandates, you secure a physically disconnected vehicle alongside an airtight legal defense. If your insurance company or the leasing agency ever attempts to penalize you for the modification, you present a legally binding work order from a licensed automotive facility, effectively transferring any potential liability and proving absolute compliance with commercial safety regulations. By fully understanding the critical distinction between legal ownership and authorized consent, by recognizing the catastrophic dangers of the third-party doctrine, and by aggressively utilizing state privacy acts and administrative revocation over illegal hardware sabotage, you have successfully transformed yourself from a passive, highly vulnerable data point into an aggressively protected, legally insulated citizen. You now possess the comprehensive masterclass knowledge required to navigate the terrifyingly complex, fiercely contested battleground of GPS vehicle tracking laws in the United States. You understand exactly how to legally shield your physical movements from suspicious spouses, overreaching employers, greedy data brokers, and massive government dragnets without ever triggering a devastating criminal prosecution. But as you meticulously lock down the data transmitting from your vehicle's dashboard, actively scrub your profile from the massive data broker servers, and safely park your newly disconnected car in your private garage, you might mistakenly believe that your absolute privacy has finally been secured. You walk through your front door, lock the deadbolt, and sit down in your living room, entirely unaware that the most aggressive, intimately invasive surveillance device in the entire history of human civilization is currently sitting perfectly quietly on your coffee table. What exactly are the highly secretive, entirely unregulated legal loopholes that allow the smartphone currently resting in your pocket to continuously map your internal home layout, silently log your private conversations, and transmit your deepest psychological profiles to foreign intelligence servers while you sleep? We are about to completely tear apart the terrifying legal reality of mobile device surveillance, and you absolutely cannot afford to miss it.